Start. Within bracket 16, the court must bear in mind one more celebrated principle and consider whether the company has reached a stage where it is obviously and plainly and commercially insolvent, that is to say, that its assets are such and its existing liabilities are such as to make the court feel clearly satisfied that current assets would be insufficient to meet the current liabilities, along with other principles. Stop para. Within bracket 17, it is also necessary to consider whether the respondent hyphen company has become defunct or has closed its business, for quite some time, whether it is commercially insolvent. Stop. For the purpose of finding commercial insolvency, a mere look into the financial data is relevant to examine about its soundness. Stop. In all matters relating to winding up, the court may have regard to the wishes of the creditors and contributories and may, if necessary, ascertain their wishes appropriately. Stop. If the company is solvent, the wishes of the contributories would carry more weight as they are persons, mainly, interested in the assets. Stop para. Within bracket 18, the element of public policy in regard to commercial morality has, likewise, to be taken into account before determining the winding up issue. Stop. The court has also to consider the purpose and policy behind sections 433 and 557 of the Companies Act. Stop para. Within bracket 19, winding up is the last thing the court would go and not the first thing to do, having regard to its impact and consequences. Stop. Winding up of a company would ensure, within bracket A, closing down of a company which is engaged in production or manufacture or which provides some services. Within bracket B, it would throw out of employment numerous persons and result in gross hardship to the members of families of the employees. Within bracket C, loss of revenue to the state by way of collection of taxes which otherwise should have been collected, on account of customs, excise duties, sales tax, income hyphen tax, etc. Within bracket D, scarcity of goods and diminishing of employment opportunities. Within bracket 20, a winding up petition has to be submitted in the prescribed form, highlighting all the facts and emphasizing the inability of the company to pay its debts. Stop. The form prescribed under the company's, within bracket, court rules, clearly, indication that the petitioner should, provide all the necessary material particulars. Stop. The petitioner is obliged to show that the financial status or the monetary substratum or the commercial viability of the company has gone so low and down that winding up is obviously, and evidently, unavoidable. Stop para. Within bracket 21, it is a settled proposition of law that a winding up petition is not a legitimate means of seeking to enforce the payment of a debt which is disputed by the company, bona fide. Stop. A winding up petition ought not to be aimed at pressuring the company to pay the money. Stop. Such an attempt would be nothing but tantamount to blackmailing or stigmatizing the concerned company by abusing the process of the court. Stop para within bracket 22. A winding up petition is not an appropriate mode enforcing bona fide disputed debts, and it is nothing but misuse and abuse of the process of the court. Stop within bracket 22. A winding up petition is not an alternative form for resolving the debt dispute. Stop. In certain cases, disputes are such that they are fit for resolving through the civil court rather than through the company court. Stop. Para within bracket 23. What is bona fide and what is not a question of fact. Stop. The expression bona fide would mean genuine, comma, in good faith, and when a dispute is based on substantial grounds or when a defense is probable and with some substance, comma, it is a bona fide dispute. Stop. It must be strictly noted that a winding up petition is not an alternative to a civil suit. Stop para. 21 dot. In the light of the above petition, comma, let us examine the financial position of the original respondent, Microforge Company, from the documents placed on record of the last 3 years and summarized in a letter. Stop. In our opinion, comma, it would be just and proper to reproduce the same to understand the financial status of the respondent hyphen company of the last 3 years. Stop. It is as per the audited balance hyphen sheet, comma, and which there is no dispute. Stop. It is as the net current assets. Stop. 22 dot. A mere glance through the aforesaid figures would lead to an conclusion that the probability of the company, comma, in substance, comma, is good and very well maintained. Stop. A mere change of 2 to 3 lakhs in profit after tax is of no consequence. Stop. Even the profit after tax, comma, in our opinion, comma, could be rated as good. Stop. In short, comma, bearing in mind the overall picture emerging from the aforesaid particulars of financial figures, comma, the profitability, comma, the turnover, comma, the reserves and surpluses, and the soundness of the entrepreneurship could hardly be questioned. Stop. This aspect, comma, in our opinion, comma, with due respect to the learned company judge, comma, has not been properly evaluated and perceived. Stop. Not only that, comma, what will be the effect of the resultant unemployment of 105 employees, comma, which is not in dispute, comma, appears to have not been placed before the learned company judge. Stop. In our opinion, comma, the impunged order does not deal in detail with the aforesaid factors, comma, which we have highlighted, comma, which we are obliged to consider before passing an order for admission. Stop para. 23 dot. It is also a settled proposition of law that in a case of disputed debt or a disputed question of fact, comma, the company court would raise its hands and it would be for the parties to get the dispute adjudicated in a competent civil court as it requires reading of evidence, comma, documentary, comma, as well as oral, comma, and appreciation of the same, comma, which is the domain of the original civil court. Stop. In our opinion, comma, there are many disputed questions of facts, comma, in the present case, comma, apart from the fact that the debt itself is disputed. Stop. Para. 24. Our attention was also drawn to the observations of the learned company judge made in para it by learned counsel Mr. Soparkar, which read as under colon. It is true that ordinarily such disputed questions of fact would be required to be adjudicated upon in a civil suit when the parties would be leading documentary as well as oral evidence, and also because Deepayan Mohanty has not filed any affidavit to controvert his authorship authorship of the fax letter purporting to be dated August 7, 1995 within bracket annexure 2 close from the petitioner to the company, comma, the Dilip S. Kumar, comma, area sales manager of the petitioner, comma, has settled in para dot 4 of the rejoinder that the fax message was shown to Deepayan Mohanty and he has denied his signature as also the sending of such letter to the respondent. Stop para. 25. It can be very well visualized from the above observations that the proposition of law and comma observations that the proposition of law that requiring investigation of facts and examination of witnesses and documents, comma, it would be advisable for the parties to go to the civil court is the acceptable proposition. Stop.